Bill C-51 was recently passed by Parliament and declared law in Canadian criminal law. And this bill was really prompted by the Jan Ghomeshi trial and what happened there. You'll recall in Jan Ghomeshi, the defense lawyer had extensive private emails and texts and other electronic materials between the complainants and Mr. Ghomeshi. And she was able to very, and quite properly, confront the complainants with this information, which showed inconsistencies with their trial evidence. And they were caught off guard, of course, and Ghomeshi eventually won his trial. And these were very glaring inconsistencies, which were commented upon by the trial judge in the judgment. So Parliament reacted to this. I say, well, now we're going to require, if defense counsel has this private information, emails, text messages, other electronic records in their possession, if you want to use those at the trial, you have to hand those over to the prosecution in advance. The complainant, the victim's then going to get those records as well. They're going to be granted standing with a lawyer to appear for them to try and suppress that information, number one. If the judge lets it in, what does it do? Well, this is great for everyone who's truly guilty, who truly did it, because if the complainant was telling the truth and did an inconsistency, well, that's of no consequence. The person should probably get convicted, right? But what about the truly innocent person who didn't do it? Now they're handing their cards to the complainant, to the prosecution, a lying victim, and there may be some lying victims out there. I'm not saying there may be some. They are now going to get a chance to get their story straight and give an explanation why there's an inconsistency, rather than being confronted on the spot in court with their lies. Now you get your story straight. So this is a great thing, of course, if a client's truly guilty, not so great for the innocent. Now, bear in mind, under Canadian criminal law, people are presumed innocent and the Crown has to prove its case beyond reasonable doubt. And we're trying to protect those people who are truly innocent in the Canadian criminal justice system. That's why the burden of proof is on the Crown. And a lot of commentators have said, and it will be, I expect, this will be challenged in court, and it may very well wind its way through the court system to the Supreme Court of Canada. It's really one of the few instances where a defense lawyer has to show their cards at a trial. I mean, there's alibi evidence where you have to show your cards ahead of time. You have to present, tell the Crown about your alibi. But I can think of few other instances, if any, where there's reverse disclosure. This is really a first, and I expect it to be challenged. And that's really been prompted by the Jan Ghomeshi trial and the developments in that trial with private records in the hands of defense counsel.